Most estate litigation cases, I describe them as every case is a mystery novel, and your primary witness is dead. And in this case, we had some very, very unusual evidence. The very nature of undue influence is that it occurs in secret.
The reason why I think it's an interesting case from an estate's perspective, it has a whole bunch of different ingredients thrown together that you often don't find. It looks pretty good, but when you dug down a layer or two, that's where I found that things didn't add up.
One Great Case, a podcast about law to learn more about people. I'm your host, Areta Lloyd.
We are discussing the Abbruzzese and Tucci case today, which was decided by Justice Gilmore on the Toronto Estates list. And this case highlights one of the most insidious, most difficult to prove claims in estates litigation, which is undue influence. Tell us about the family. Who were they?
First generation Canadians were the parents, mother Assunta, and father who predeceased her back in 2005. And there were two daughters. And there was the daughter Bernadette and my client Angie. And they were living in Toronto at the time of the events in question. Bernadette was actually living with her mom, but as a first generation immigrant, Assunta, the mother, did not have strong English language skills and was, in our view, certainly reliant upon her children to navigate through the fact of living in Toronto after her husband died.
Would it be fair to say that she was somewhat illiterate? I read that she only had a grade 3 education from back in Italy.
That is true. That fact didn't play an enormous role in the ultimate findings, and it didn't really contribute to any findings of capacity because literacy is not necessarily connected to capacity at all.
Mm-hmm. But she was reliant in her old age on at least the daughter who lived with her, and that was Bernadette.
Yes, absolutely. And in addition, she had some health issues that restricted her mobility. So she was, in most respects, restricted to her house and was reliant upon Bernadette to bring her effectively what she needed to live, whether it was food or anything else. But it also meant that Bernadette was able to control access to her, and that was certainly one of the factors that came into play, and the element of cloistering was quite prominent in the evidence and in Justice Gilmore's decision.
And so we've mentioned a few facts relevant to the case. Just expand on that a little bit and tell us. I read that. I think the case went on for a very long time. It started before she died. So tell us a little bit about the progression of the case and what was your client trying to get?
Certainly. It started, there was some friction between the sisters. And in 2016, my client discovered that her mom had transferred her matrimonial home to her sister for no consideration, and also had some information that her sister was the power of attorney for property and for personal care. So that was back in 2016, and the proceeding commenced as an application to set aside that transfer and also to set aside the power of attorney. And so that progressed for a number of years. And as a result, there were some examinations while mom was still alive. And these included...
Did you examine the mom while she was alive?
So the former counsel in this file, I did not have carriage of this file while mom was alive. It was Solicitor Michael Handler, who has since retired, but an excellent solicitor in his own right. So he conducted the initial examinations, but most importantly, he had arranged for mom to be assessed by Dr. Bruto in 2017. So Dr. Bruto conducted 7 or 8 assessments over 3 separate attendances and ended up with a very comprehensive set of reports commenting on Asunta's capacity to manage property, her capacity to make a will, her capacity to make a power of attorney, both for personal care and for property, and also a retrospective opinion because the examinations were conducted in 2017. She conducted a retrospective assessment as to whether or not she had capacity in 2016 when the power of attorney documents and the transfer itself was conducted. So before I even stepped into this case, there was already a wealth of evidence that was quite supportive of my client's position, at least in respect of capacity. The building of the undue influence case was something that we managed to actually work on and put together some fairly good evidence.
So the case started out as a incapacity case. And was there any doubt in your mind to her capacity to make such a large inter vivos transfer? Did you think that was a solid case? Why would you go ahead and try to prove undue influence, which is so difficult?
Well, I think it works the other way around. So to answer your question, yes, we were quite confident that we had a strong case on lack of capacity, but that allowed us to take perhaps more risks and pursue the undue influence case, knowing that if we weren't successful in undue influence, we'd still have a strong chance of success on the capacity issue. And as it turned out, Justice Gilmore found both lack of capacity as well as undue influence. So yes, and the two feed into each other, of course. So a person who has diminished capacity, the bar for proving undue influence may be somewhat lower as a result. But yes, it was a very interesting case in many respects. Let's
talk about the evidence, because I think that's like one of the most fascinating parts of this case.
Well, I like to describe most estate litigation cases. I describe them as every case is a mystery novel, and your primary witness is dead. So what that means from counsel's perspective is that you have to put together a case largely from circumstantial evidence. And then you have to be able to present it in a format that is convincing enough for a judge, that a judge can be comfortable that the inferences that are being drawn are supported. And in this case, we had some very, very unusual evidence that came to play. And I mean, the first part was, well, let me start. So what we do, and what I did in this case, certainly, is you start with the law. You start with the Gironda case, and the which set out the indicators of undue influence. And so it's whether or not there's evidence of dependency, whether or not this testator is socially isolated, whether there's recent family conflict. There are a series of indicators.
Like bereavement, recent bereavement, although the factors are not exhaustive.
Exactly. So when I was conducting the investigation, we were starting to find evidence that was checking all these boxes off. And then we got to the end, and I thought, well, I doubt that this is still enough, that we need something more. And then there were two particular pieces of evidence that were that turned out to be very, very helpful. The first was the evidence of Dr. Bruto in the reports from 2017. Now, Dr. Bruto was just retained to comment on capacity and provide an opinion on capacity. But what she did as well was commented on behaviors that she noticed with Asunta. And in particular, she was commenting on behaviors of what she called ritualistic statements. In other words, she noticed that Assunta would voluntarily just start saying things about her daughter Bernadetta, and starts in a positive light, and start saying things about my client in a rather negative light. And Dr. Bruto picked up on this.
And I think she said it randomly, like when it was not necessarily appropriate, where they weren't discussing that.
Exactly. And repetitively too. So she picked it up, but makes no comment on undue influence. It's just there. But it ended up being quite central to the case, because one of the most remarkable pieces of evidence that we obtained were a series of tape recordings. And as happens in quite a few estate litigation cases, in this case, both sides were recording their conversations with their mom. And
how did you get that? How did you find out that Bernadette was making recordings?
So there had been an indication from my client that she was recording and that she knew that her sister was recording. And so we made demands for full production of those recordings, and counsel absolutely, to his credit, produced the recordings. And they arrived in my office. That just literally, they were digital transcriptions. They were all in Italian. I had no clue what they said. And so I sent them off to my client, said, can you just give me a rough translation of what they were? And when they came back, I could not believe what was on these recordings. It was essentially Bernadetta coaching her mom on what to tell her own solicitor in an upcoming meeting. The recording then continued because she recorded the entire meeting with her own solicitor. And of course, during the course of the meeting with the solicitor, mom repeats these ritualistic phrases that she's been told to say by Bernadette. This was obviously terrific evidence and absolutely corroborative of what Dr. Bruto had indicated.
And when you have that kind of evidence, you think, okay, they're going to settle.
Yeah. Nope. Estates litigation is driven by a number of factors that, and they're not always the most rational factors. Regardless, in this case, we had the opportunity. Not only did we have these tape recordings, but we also had the opportunity to conduct an examination of Solicitor Angelini, who was the lawyer who Assunta met with. She was, in fact, Assunta's counsel. So we conducted an examination of a witness and put the tape recording to her, and her evidence was that it was consistent with what her sense was at the time. So when this evidence gets introduced at trial, very, very powerful evidence.
Yeah, and by the time of the trial, Assunta had already passed away. So,
yes, that's right.
He then testified, after she had already passed away. That's
right, and so the nature of the case changed from simply an application to set aside a power of attorney and to set aside the transfer to a will challenge as well. So there was still the application to set aside the transfer of the property, but now there was also the will challenge.
And so you had these two great witnesses. And tell us a little bit, in your mind, what makes for a great witness? I sometimes think it's a little bit of preparation, a little bit of talent on the witnesses.
Absolutely. I mean, the comprehensiveness of the reports, firstly, for Dr. Bruto, was, to her credit, certainly one of the best that I had seen, and the ease with which she could summarize the facts that she relied on and provide her opinion and stand up under cross-examination and stick to her opinion, they were all absolutely first rate, without question. And in terms of the other witnesses, my client, certainly there were findings of credibility made by Justice Gilmore, and so Her Honor certainly found that Angie, my client, was credible. So those are obviously very strong factors that come into play when it comes to the decision. But it was also, there was a lot of evidence that's put in. The decision itself runs to, I think, some 60 pages or 80 pages, depending upon what platform you look at it. And that is a lot of evidence in the course of a 7-day trial. Much of the evidence went through it was a hybrid trial. So much of the evidence of the non-party witnesses, the evidence in chief was tendered by affidavit. And we proceeded by having a 10 to 15 minute warm up of our own witnesses who were then subject to cross-examination on their affidavits. So the parties themselves, it was full examinations in chief, but all of the other witnesses were done by affidavits and then cross-examined. And so there's a certain amount of preparation that you do for the witnesses. Personally, I don't like to over-prepare them because my personal view is that you don't want their evidence to come off as rehearsed. And it seems in this case, the evidence went in quickly, went in very smoothly, and there was also a great deal of medical evidence that went in as well that was relied upon. So all in all, it was a very efficiently run trial. And again, I have to thank my associate Genevieve for all the work that she did and assisted both in the research and in the presentation of the evidence itself.
And in the end, your client seems to have gotten her, and was it substantial indemnity costs?
Yes, the costs were ordered payable by Bernadette, but also payable out of the estate. So when Angie was entitled to certainly substantial costs from Bernadette, payable out of her share of the estate, but also entitled to indemnity as an estate trustee from the estate for her legal fees. So yes, it was not a straightforward cost order, but at the same time ended up being, I think, ultimately quite fair to all the parties.
Yeah, I think the most interesting thing out of this case, though, is that concept of ritualistic conditioning. And I don't know if that's going to become a thing. I certainly would love to use that in my own cases because you see it all the time.
You do see it, and it is very difficult to prove. As you know, the very nature of undue influence is that it occurs in secret. So how do you tell that someone has been coached to say these things? Very, very difficult. And of course, if you took it at face value, you would have the respondent, Bernadette, saying, my mother tells me that she's giving this to me because of all the things that I do for her. And you have mother saying exactly the same thing. So if you're on the other side, you say, well, you've got evidence of mom that's corroborated, or evidence of Bernadette that's corroborated by evidence of mom. And there's no disputing that the mother's actually saying this. But you're quite right, is to be able to say that it's not just what mom said, but the manner in which she's saying it and in the circumstances in which she's saying that. So yes, certainly the stars aligned in this case. The evidence was really good for my client, and the result was absolutely correct.
Yeah, it was a great undue influence case, I have to say.
Well, thank you. Yes, I do have to say that it is definitely the facts that drove this case and drove this trial. And we were fortunate enough that the investigation turned up facts that were really supportive.
Yeah, they are all fact driven. Very interesting, David. Well, thank you so much. We are actually going to speak to Justice Gilmore about how she came to her decision and a bit what she thinks about undue influence cases.
Well, I will definitely tune in to watch that. I'd be fascinated to hear her Honor's comments.
Well, Justice Gilmore, thank you very much for agreeing to speak with me today about the Abbruzzese case, which you decided. As an estates list judge for several years, you are essentially a specialist in estates litigation, I think. And you must have presided over so many undue influence cases. Why are they so hard to prove, do you think?
They're hard to prove because it's up to the person alleging undue influence to prove it. It's their burden of proof. And it's really difficult because all the evidence you need relates to a person who is deceased and interactions with that person from the time they were alive. So it's hard to marshal that evidence a lot of the time. And even though numerous factors can be considered, usually not all of them are present, except in this case, when all of them were present, as I found. I should note that it's not necessary for the person to be incapable for undue influence to be found. They often go hand in hand, but they can exist separately and independently. And this is a case where I made both findings, that the person was incapable and the subject of undue influence. But as I said, there's cases where undue influence has been found where the person was capable, but their will was overcome as a result of the facts in the case.
Yeah, I mean, obviously, that second part is so much harder when somebody is capable. And David also mentioned this, that he was able to take a gamble on this undue influence claim because he was so sure that he would succeed on testamentary incapacity.
Right. So in this case, I found testamentary undue influence and testamentary incapacity. There were also cases of presumed undue influence in this case in relation to the transfer of the home from the mother to the mother and the daughter. So the reason why this case is interesting is it has so many different aspects, not all of which are always present together in a case. So there was presumed undue influence in relation to the transfer. And in that case, the daughter who received the benefit of the transfer had to rebut the presumption of presumed undue influence. We had testamentary undue influence and all the various factors in the Gironda case that I considered. And then we had capacity issues with multiple experts' reports to be considered. So the reason why I think it's an interesting case from an estate's perspective is it has a whole bunch of different ingredients thrown together that you often don't find. And I should add one of the other things in this case was the solicitor's evidence who drafted the will. That's often a component in a will challenge that you will find, but it was certainly present here. So that was there. And then we had the very peculiar part of this case, which I relied on quite heavily in my decision, where the mother was recorded by her daughter during an interview with her lawyer. So that was also evidence that I relied on with respect to my finding of testamentary capacity. And I would wager that that kind of evidence is not always available in every case.
Yeah, it was pretty surprising to me reading the case that this evidence even came to light. And I did ask David about that. And so, the fact that you had these recordings, and it wasn't just the interview with the lawyer, I think it was that the daughter was coaching the mom, and that was also recorded. Am I right about that?
Yes. So interestingly, the recording was one of the productions that was made by Bernadette, the daughter, who was unsuccessful in this case. And the beginning of the recording it starts out with Bernadette talking to her mother and telling her what to tell her lawyer. And it's not just what she was saying, but the words she was using, which I then relied upon again in other parts of the case to say that the mother in this case was unduly influenced because she kept repeating these same things that had been told to her by Bernadette, and Bernadette had kept reinforcing to her that she had to repeat them. And I found that she repeated them to her lawyer, that she repeated them to her medical professionals, that she repeated them to Dr. Bruto, one of the experts. And so this permeated the entire case, this what Dr. Bruto framed as ritualistic repetition of certain things in relation to what Bernadette had done for her and why the mother felt that she had to therefore give Bernadette this property and favor her in the will.
Yeah.
So
and the lawyer,
it was all connected.
Yeah. And it's, I mean, I know that, when you have the evidence of a drafting solicitor, and certainly he seemed like somebody who did the job, and he wouldn't know that this was happening, and he wouldn't have had that medical report necessarily. I think he said sometimes he would ask for capacity assessments, but in this case, I guess her social P's and Q's were so intact that he just didn't suspect it. And normally that kind of evidence is relied on to a great extent by a court.
I have to be frank with you, Ms. Lloyd, that was one of the biggest thresholds I had to get over in this case, was trying to deal with the lawyer's evidence, because on its face, you're quite right, and in his notes, it looks pretty good. But when you dug down a layer or two, that's where I found that things didn't add up. And so some of the reasons that I found, which led me to reject that evidence, which in many cases the courts rely on quite heavily in will challenge cases, was first that the mother was repeating to the lawyer those same ritualistic phrases as to why she was giving Bernadette the majority of the estate. That if the lawyer had dug down a couple of layers, he would have discovered a couple of things, such as the fact that the mother thought that she still had $80,000 in her bank account, when by the time she went to see him, Bernadette had actually removed most of the money in that bank account. But she didn't know that. So that was kind of tied to her vulnerability. And so, Dr. Bruto came to kind of the same conclusion, which was that Maria, when you first met her, she seemed fine, except when you peeled back the layers of the onion a little bit. You thought, well, she keeps repeating this same phrase over and over again. And that it was Dr. Bruto's opinion that, if you didn't go that step further, that you quite possibly could come to the wrong conclusion about her capacity. So I relied on that. Oh, and I think there was one other thing. Given that I'd already found that she was the subject of undue influence, I found that because Bernadette drove her to and from the appointment to Solicitor Bambaka, that I inferred that she may have been, just as she had with the lawyer, telling her what to say to Mr. Bambaka, just as she had told her what to say to Section 3 counsel. And I thought that was a reasonable inference, although I was a bit nervous about it, didn't get overturned by the Court of Appeal. So all of those things together, I relied on to reject at least most of the solicitor's evidence in terms of Maria being capable and understanding what she was signing. I gave a couple of other details as well that I felt didn't fit, but those were the main ones. But you're quite right, Ms. Lloyd. One of the things I look for, and this is all a warning for will drafting solicitors, their notes with respect to these will cases are critical. So if you are a will drafting solicitor, make sure that you put down not just the instructions, but your observations of the individual. It's so important going back, because there's nothing, it's very hard to understand what happens in those interviews because it's just the lawyer and the client. Sorry, I went on for quite some time about that. Sorry.
Oh, no, that's all right. And, it's interesting. The Court of Appeal commented on the thoroughness of your decision, and any lawyer taking on such a case would do well to read your decision, even though they might not have the same evidence or breadth of evidence as David did in this case. The interesting thing is that it sounds to me that they started this case when she was still alive, and having that contemporaneous assessment or the several assessments was really important.
Mm-hmm. Yes,
yeah. And people ask, clients ask, well, or you see clients maybe later who say, I think my mom is being influenced. But if you're not in there, I feel that if they're not in there right away, challenging, it makes it so much harder for them after they pass away.
Yes, and Dr. Sarah Mitchell's report, and she's a very well-respected expert. I take nothing away from her. Unfortunately, she had to do an assessment after Maria had passed, so it was much more difficult for her. And I found that I just couldn't rely on her assessment to the same extent as I could the contemporaneous one, for obvious reasons. Now, the other side argued that, of course, that contemporaneous assessment was done after the mother had been diagnosed with dementia and was in a much different place than she was when she signed the will. But it's interesting because one of the things I relied on was Bernadette in this passing of accounts application. And people who are following this case know that there was a prior proceeding in a passing of accounts application that I also presided over, in which I found that Bernadette was required to repay money to the estate because she'd either misappropriated it or couldn't account for it with proper vouchers. So she had already been found by me to have some issues with respect to her credibility and honesty. And so when we got to the expert's report, and the mother's capacity, Bernadette had said in the passing of accounts proceeding that her mother had been reliant on her and dependent since 2006. At the trial, she changed her evidence completely and said, it was much later than that, because of course she didn't want the court to think that her mother's health and particularly cognition had been declining since 2006. So there was, even though there was an argument that, okay, the best case scenario is you prepare your assessment on the day the person signs the will, even though we didn't have it that well aligned, there was still other evidence that pointed to a decline in this mother's cognition going back some period of time.
Yeah, and it's interesting. I know capacity assessments are considered to be quite onerous for the person who's incapable, but they do have a place, and there's such important evidence as it showed in this case.
Well, especially Dr. Bruto's labeling of those statements, the ritualistic statements, mm-hmm. which I relied on a great deal in my decision. And actually, a part of the decision kind of parses out all those ritualistic statements and to whom she made them at various times, just to make it clear to everyone that this wasn't just random and it wasn't just one time, that it was a series of statements, same statements made time and time again to different people, which led me to conclude that she was influenced by Bernadette to say them. And again, the marrying of undue influence and lack of capacity, she was vulnerable because she did have a decline in cognition, and as a vulnerable person, therefore more susceptible to undue influence. The two are kind of inextricably tied at certain points in this case.
Yeah, as they usually are. Mm-hmm. I think Dr. Bruto may have introduced a new concept in undue influence cases.
I think she has. And I think it's not uncommon. And in fact, those of us who do estate litigation all the time, and we hear in cases all the time, and you read medical evidence, you see reports, one of the signs of advancing or advanced dementia is repetition of stories, phrases, and so on. So this is not a new concept. But I just like the way she labeled it.
Yeah, that was really great. Okay, well, thank you very much for being with us. And again, I think people should read that Court of Appeal decision.
I will say it's very complimentary to me, Ms. Lloyd. I was very pleased to see their remarks because I did work hard on the case, but the Court of Appeal sometimes isn't complimentary to judges, so I certainly appreciate that.
Take it where you can get it.
Exactly.